Hi Ali, my name is Vanessa Hadley-Spencer and I'm going to be advising you today. I've had a look at your scenario and this is my advice. We need to look at your employment status to ascertain whether or not you are an employee. This is because the greatest protection is given to employees under employment law. Only employees have the right to claim unfair dismissal, statutory maternity pay, statutory redundancy pay, statutory sick pay, and are entitled to minimum notice periods. Right, firstly, looking at the statute. Section 230, subsection 1 of the Employment Rights Act 1996 defines an employee as someone who has entered into or works under a contract of employment. A contract of employment is defined in section 230, subsection 2 as a contract of service. This is an important distinction between employees and workers, as workers usually enter into contracts for service. These statutory definitions aren't very useful as they don't tell us clearly who is and who isn't an employee. The courts have developed a number of common law tests to help us ascertain who is and who isn't an employee. Firstly, looking at the control test. This originates from the case of Younes and Noakes. The control test is simply that the more control an employer has over an employee, the more likely it is that they are to be an employee. This has been developed in Walker and Crystal Palace FC and White and Troutbeck. These cases established that if the employer is controlling the hours an employee works, where they work, who they work for, then it is more likely that they are to be an employee. Looking at your situation and applying these cases to you, you have to work in the showroom when they ask you to. You have to go to the clients that they give to you. You also have to wear their uniform. But most importantly, if you are going to lose a client, the company intervenes and reduces the price, which results in a reduced commission for you. Now, this level of control, I believe, strongly indicates that you satisfy the control test and are an employee for that purpose. Moving on to the integration test. This originates from the case of Stevenson and Jordan. The integration test is whether or not the employee is part and parcel of the business. This asks, quite essentially, whether the employee does anything other than their main role. Looking at your case, you do sales for the company, door to door, to the customers they tell you, but you also run the showroom. This strongly suggests to me that you satisfy the integration test as you're doing something other than your main sales role. Moving on to the economic reality test. Now this one doesn't work in your favour so well. This test asks whether or not the employee is making a profit for themselves and whether the worker has anything to gain by being part of the organisation. It also asks whether they've taken any financial risk or made any financial investment. Now, you pay your own tax and national insurance, which would suggest that there is some element of self-employed, as well as the fact that you give gifts to your customers. Now, you've made that gift investment from your own pocket, which suggests that you're putting in something to the company. The fact that you're getting a commission as well for your sales suggests that you make a profit for the work you do, which suggests that there's this element of self-employed there as opposed to employee status. Moving on to the multiple composite test, as in ready-mix concrete. Now, there are three elements to this test. The first being that there is control to sufficient degree, the second being one of personal service, and another being that the provisions of the contract are consistent with that of a contract of employment. Now, this has been developed to control, personal service, and mutuality of obligation. Firstly, looking at control. As we did earlier, we established that because you have to wear a uniform, because you run the showroom, because they tell you who your clients are and interfere when the client's going to be lost, it is likely that they do have control to a sufficient degree, and that element is satisfied. Looking at personal service. This is the idea that you have to do the work yourself, and an ability to send a substitute is usually fatal to employee status. This was established in the case of Express and Echo newspapers. Looking at the developments in that area, there is a case of McFarlane and Glasgow City Council. This was the case of a gym instructor who, when she was unable to work, was able to choose from a list of colleagues to replace her. Now, as the right to choose a substitute was fettered, this meant that she was still an employee. This, I think, applies to your case, as you can only choose from a list of HPC team members, and you can't just substitute yourself for anybody, which suggests to me that you being able to swap for members of the team isn't fatal to your employee status, and you have satisfied this element of the test. Moving on to mutuality of obligation. There are two elements for mutuality of obligation. The first is that there must be a contract, and the second is that the employee must be obliged to accept the work, and the employer must be obliged to give the work. This is usually a problem for casual workers, as this mutuality of obligation doesn't exist in their contracts, and this is where they fall down. Looking at the case of Wilson and Circular Distributors, this concerned a relief manager who wasn't given work all the time. However, when work was available, he was given it and he was obliged to do it. The courts were able to find that there was a mutuality of obligation despite the fact that there were gaps in his employment. I think that this set of facts applies very directly to your case, Sally, as HPC find work for you by giving you customers, and you're obliged to go to those customers. And if you can't make those appointments, you have to replace yourself with someone else. This strongly suggests that there is a mutuality of obligation in your work, and this element is satisfied, indicating strongly that you do have employee status. Looking at other provisions of the contract. Now, just because a contract says somebody is an employee, it doesn't mean to say that they are. As in the case of AutoCleanse, the courts will look more at the relationship with the employer and the worker and the employer have, as opposed to what the contract says. This is to prevent fraud and prevent the employer from wiggling out of giving key employment rights. Now, the case of Hall and Norrimore states that you need to look at the whole relationship and paint a picture of the employment relationship as a whole. Now, looking at your scenario, we've established that you satisfy most of the tests except for the economic reality test. This would strongly indicate to me that it is more likely that a court will find that you do have employee status than not, as you are part and parcel of the organisation, you do have a mutuality of obligation, and you do work in the showroom when required to.